Do me a favor, come to the closer desk. I'm not going to bite either one of you.
Good morning, Your Honor. Angela Lipscomb for the Plaintiff Hawk Technology Systems.
Okay, Ms. Lipscomb.
Good morning, Your Honor. Robert J. Vanderwall for the defendant, Brickell, etc.
Okay, please have a seat. As my law clerk, and let me officially introduce him, Arun Ravindran has informed you, we are participating in the National Cameras in the Courtroom project. So all proceedings are videotaped to be shared after they clean it up. I understand that Ms. Lipscomb, you've already filed the consent, and Mr. Vanderwall, you are going to file it.
I already did. I put it up on the desk there. I've consented.
Okay, thank you very much.
Thank you.
But I thought, hold on just a minute. Mr. Vanderwall, for those of us that have been around since typewriters, there's a new world, and if you would please take your consent back, I'm going to have my law clerk give that back to you. It has to be sent by email in, and that's how the clerk's office has the official record that can be transmitted to the administrative office of the court. So if you would do that for me, I would appreciate it very much.
Absolutely. I apologize.
No, that's okay. It's opportunity to learn some new tricks, and I'm still learning. And I don't know what I would do without my more facile law clerks and my wonderful court staff. Please have a seat, sir.
Thank you.
We're here on the parties' joint scheduling report, and I consider this a very important first meeting because it sort of lays the groundwork and the philosophy. I am very interested that everyone in the courtroom understand that we are a tripartite partnership and that we all have an obligation, counsel particularly, to balance their zealous advocacy with their responsibilities that always trump being an officer of the court. And therefore, we have an obligation to make sure that this case is expeditiously and cost-efficiently resolved pursuant to Rule 1, not only the letter, but the spirit. And so I constantly urge the parties to counsel and ask the counsel, as officers of the court, if I need to bring in any of the executives of the respective parties to help them understand the philosophy here. I will be happy to do so. But if there are any questions about that approach, I am available because I am a member of also of the National Pilot Project on patent cases, and so I have made a commitment to spend the time on these cases that are necessary. My paired magistrate, right now it's Judge Symington, and soon, by April 1, it will be Judge Turnoff. I work very closely with my paired magistrate on all discovery issues so that if there is a discovery dispute, counsel have an obligation to work together to try and resolve it. If in a good faith effort, and lawyers, one of the gifts that they have is the ability to problem solve and to listen first, seek first to understand, and then to be understood. If you cannot resolve it, you will have at least teed the issue up. You can call on Friday and get right in the next week so that it can be resolved without the need of filing a lot of paper. Our goal is to help the parties keep the costs down and to resolve the case as quickly and as efficiently as possible. I would like to accomplish several things here. The three most important ones is understand both of the parties on either side in a most cost-efficient manner. So a little quick introduction to the respective parties and what they do. It also is helpful to me to have a little understanding about counsel and counsel's experience in handling patent cases. I'd also like to go over understand a little bit about the patent and how the plaintiff has acquired the patent, and a little bit of the prosecution history of the patent, because I see that there has been 2 reissuings of the patent. That's just for general background. And then I noticed in looking at the joint notice of terms genuinely in dispute, that is not a statement of statements that are in dispute. That's sort of issues that the parties plan to litigate. I think we need to come back and be more focused. And the last thing I'd like to discuss, maybe I want to discuss this after I hear a little bit about the parties, is that I've noticed that the plaintiff has filed a number of cases in this district against various defendants. 4 of them have been settled. In one case, they were sued by another company. That was in front of Judge Middlebrooks, and that has been... So cases are filed and settled early. I like settlements because it keeps the cost down. I'm just wondering, it made me wonder more about the plaintiff and the plaintiff's business model and understanding the plaintiff's interest in the particular patent. I also noticed that there are 3 other cases that involve the plaintiff that are in front of me. In 2 cases, the plaintiff is the plaintiff, and in the 3rd case, you are the defendant. So, first, educate me about the, if you would, Ms. Lipscomb, about your client, how it acquired the patent, sort of what is its approach, and then tell me a little about yourself, and then I will chat with Mr. Vanderval about his client and about himself.
Sure, Your Honor.
And you can have a seat if that's more comfortable. If you'd like to stand, why don't you come to the podium, and then you're closer to the microphone, which will help my court reporter.
Okay, sure. My client, Hawk Technologies, acquired this through an assignment, acquired the patent through an assignment.
And how did it get the assignment?
The inventor of the patent, Mr. Barry Schwab, there's actually 2 inventors. It's Mr.
And do me one other favor. See this wonderful court reporter?
Yes.
She's fast.
But I'm really fast. Okay. I'm happy to slow down.
You need to have a conversation with me. If not just to help her out, but if you're a fire hydrant, it's hard for me to absorb, okay?
Yes, Your Honor. There are 2 inventors. It's Mr. Barry Schwab and Mr. Ken Washino. And Mr. Washino, I believe, gave his rights, assigned his rights to Mr. Schwab. Mr. Schwab, in turn, assigned the rights to Hawk Technologies. I believe I'm stating that correctly. I don't have the actual assignment.
And who's Hawk Technology? Is it simply a holding company?
I'm sorry?
Is it simply a holding company?
It is an entity that was created to enforce the patent, but the Mr. Schwab is part of that entity and is very much involved. And
But why isn't he in the business of producing his patent?
they actually tried, but because the market was already so saturated, it did not, they couldn't get it off the ground. And the company in which they tried to actually build the systems, it didn't work. They wound up filing for bankruptcy, I believe, or never. They couldn't do it. It wasn't a viable business model because there were already too many major players with more money that had already started using the.
And when did they start trying to manufacture?
Your Honor, I'm not sure about that. I have had numerous conversations where it was explained to me that they couldn't make it a viable business entity, but or wasn't a viable business model. But I'm not sure how long that they've tried.
Was it in the 90s? Was it in the 2000s?
No, I believe it was in the last decade. Yes.
So, and I see that they sought a reissuance of the patent. Why was that?
It was to clarify some portions of the patent. I think there was just some wording in there that they had used. There's a couple of provisions in the patent where it was inconsistent, and so in order to make it more consistent, the language throughout the claims, it was reissued and amended for that purpose. It wasn't, the scope of the patent wasn't changed. It was simply to clarify the language that was already in there. In other words, there would be a word in one portion that another word was used, although they're the same, they had the same meaning. It was just basically to clarify the claims. That's
okay. And when was Hawk created? Hawk Technology.
Trying to see if I have the. I didn't bring. I apologize, Your Honor. I didn't. I didn't bring all of that information with me. I'm not entirely sure when it was created. I wish I had the. If I'd known, I would have brought the assignment with me, and I could have gotten it on the PTO's website, but I don't have it with me, and I'm truly I'm not sure.
And its principal place of business is at your office?
Yes, Your Honor. They have an office. They are subletting from us, or in the same area as us.
So is it in the business of licensing its product?
It has been. It has. It's the settlements have been confidential, but I can say I believe that it's been a part of that. A portion of some of the settlements have been to provide a license. Correct.
So when did they file their first suit to enforce the patent?
There was a firm before us that they had used, and I believe their first cases were in Texas, and I believe that those started last year. I believe mid last year. I do have I believe we filed the notice of related cases, but I don't have it with me. And I know that the first cases were filed in Texas, and I know that was done last year.
Okay. Tell me about yourself and your experience in patent work.
Sure, Your Honor. I actually just joined my firm, Lipscomb, Eisenberg & Baker, in October. Before that, I was with Ackerman for the last, I believe, 7 years. And before that, I was with a firm in Miami, 2 Cardenas, and have done litigation, predominantly general commercial litigation. But we do have, Ackerman does have an intellectual property practice that I worked with for the last few years, and am doing again at my current firm also general commercial and intellectual property litigation.
Okay, thank you very much.
You're very welcome. Thank you.
Mr. Vanderwall.
Yes, Your
Honor. Tell me about your client, Brickell Financial Centre.
It's a building, essentially a new building, commercial building on Brickell. It's been opened I understand, about 2 years. I have no history representing this client except for this case, so I don't know that much about them. But anyway, they retained me because I have a lot of experience in the patent field.
Tell me about that.
I started as a law clerk. Later this year, it'll be 40 years ago.
Oh, you're a young guy.
I have been, some people have referred to me as the dean of the patent bar in this community.
Mr. Vanderbilt, I hate to tell you this, but you're out of law school less time than I.
Pardon me?
You're out of law school less time than I.
Oh, yeah, I know, but I've been doing patent work since before you were president of the Florida Bar.
Okay, you got me there.
I was originally clerking for a firm that was going to hire me, but they ran short of money because the real estate market, which was a good part of their practice, had kind of crashed at that point, and they referred me to a Chicago patent attorney, since passed on, but he was senior partner of a Chicago firm, and he had a national practice, and he was very good, and he taught me a great deal. And I worked for him for a year or so. He made some promises that he didn't keep, and that led me to go elsewhere. And then later on, after some time passed, he invited me back, and we became partners in what was then the largest patent firm in the state, Dominic Stein, Secosio, Reese, Collitz, and Vanderwall.
So you and he kissed and made up?
Excuse me?
You and he reconciled?
Yeah, kissed and made up. I got you now. Actually, what happened is he invited me to dinner to make a proposal that I come and become a partner of the firm. And I initially told him no. And he said, why? And I said, because we didn't get along one time before, and I don't see why it would be any different this time. But he persisted. He asked me out to dinner another time, and I went. And I said, okay, I've given this some thought. Here's the deal. I will keep my own office open, but I will come up here and bring a secretary with me and keep files that are active here, and we will see how it works. And if it works, then I'll close my office. And if it doesn't work, no one will know the difference, because I'm putting in a dedicated phone line that'll ring from my office in here. And it worked. I only had to tell him off once, but I had my own practice at that point, so it worked fine. And then, I guess close to 10 years later, he was starting to get in trouble with courts because he was a very belligerent fellow. And he started to make some mistakes, and I didn't want to be tarred and feathered with that brush, so I left. But he was a fine lawyer, a good teacher, and unfortunately now he's passed on. So I've been doing patent work for close to 40 years. I began clerking for him in the fall of 1974, and I graduated in December of 74 from the University of Miami School of Law, and then I joined, his name was Jack E. Dominic, and I joined Jack's firm, and later on, he of course became the senior partner of the firm down here. He wasn't the senior partner of the Chicago firm any longer, although he still had an office there. He took me to a jury trial in my first year in Chicago. The trial lasted 4 weeks. It was bifurcated, so we were just dealing with the issue of liability. It was one of the most interesting patent cases you'd ever run into. There were two patents that covered the same invention. They didn't look alike, but they covered the same invention, exact same invention by the same inventor. What happened is he had disclosed his invention to his employer, got into a dispute with the employer, left and went to another firm and disclosed it again, and both firms decided to file patent applications on it, and the patent office didn't catch it, so they issued 2 patents on the same invention. Made for a very interesting patent case. I've never seen another one like it.
How did it resolve?
The jury, well, this guy was a very, very good jury trial lawyer, since in those days, most patent cases were tried to the bench. But he believed in juries, and he told the jury, and remember this is in Chicago, he told the jury he had arranged all the special verdicts in a certain way so that in summation, on the second half of the summation, when he came back up, he told the jury to vote a straight ticket. And in Chicago, that was funny to everybody. Even the judge laughed at that one. So they did. They came in with special verdicts, all in our favor, in about 3.5 hours after a 4-week trial. He managed to keep all but one juror awake most of the time. And with a patent case involving, I guess there were about 200 part numbers in each of those patents. It's interesting how with 2 different patent attorneys and 2 different patent draftsmen, you get 2 things that don't look anything alike at all, but they were the same invention.
So did you all represent the first to file?
Yes, we did.
Okay.
And also the other lawyer had trial experience, but essentially no jury experience. So that was
That really makes a difference, doesn't it?
Yes, it does. So I've been a believer of jury trials in patent cases for a very long time, and I love juries. I don't always win, but I love juries.
I'm a great believer in juries, and I do believe that they try and do their very best, and our job as part of our tripartite partnership is to make sure they have all of the tools to fairly dispassionately decide the case based on the evidence and the law.
I think it's admirable that you have elected this role of trying patent cases, and it's good for the patent bar as well as the judiciary, because you have the occasion to try more cases and to learn more than the other judges, and it's been my experience over all these years that every time you try a patent case, you end up with a different judge, and the judge doesn't really like patent cases, and the fact that you and Judge Middlebrooks and
Judge Moore,
right, that the 3 of you have agreed to do this I think it's a very good thing, because we're going to get a better patent judiciary as well.
let's hope and pray that that happens. But a lot, as you and Ms. Liscombe know, depend on the lawyers truly being the masters of their craft and being what I'm so proud of. It's still hard for me to take my Florida Bar presidency hat off because it gave me an opportunity to compare the lawyers in Florida with the lawyers around the rest of the country. And I came away from that experience very, very proud of the lawyers in Florida. Having said that, I have very high expectations, and I don't like to be disappointed, and I don't suffer fools gladly.
Well, I have had several opportunities to be instructor to some judges. I started out, I spent quite a bit of time with Wilkie Ferguson, God rest his soul. I love that man. And he publicly acknowledged it. He came to a Patent Bar Association meeting, and he praised me so much that I got embarrassed. I wished I hadn't hadn't been there.
Well, Mr. Vanderwall, then you are going to be on, I'm going to hold you to an even higher level. then I will to Ms. Lipscomb, since you have been the dean of the patent bar, and
I don't call myself that. That's what other people have called me.
But you know, the reputation is there, and as you said before, you don't want to be associated with people that are not living up to the highest levels of our profession, especially when they have the talent to do so. I think that's what disappoints me, is when I see somebody who is very, very talented not living up to their potential. What a waste of the gifts that they have been given. And I see my job as not only to promote justice, but to make sure that when we try the case, the lawyers have the opportunity to show the members of the public who otherwise would not be exposed to the value added that lawyers provide, why they are the masters of the craft. And it's beautiful when it happens, and I love it.
Well, I'll try to do my best.
Okay.
I would like to make one comment or two about the patent in suit. Mm-hmm. We disagree with the statements of the plaintiff just now in a couple of respects. This patent was, in our view, reissued to try to bulletproof it from invalidity claims.
I see that already. That was my first. Anytime I see a reissuance, and that's why I asked Ms. Lipscomb, okay, when did the bankruptcy occur? Why is? I mean, you know, I wasn't born yesterday.
I'm aware of that. So that's the primary reason for the reissue, but it was also broadened, contrary to what counsel represented. You have to file a reissue application within 2 years of the original issuance of the parent, and they did it on the last day in order to be able to broaden the patent, and they did broaden the patent.
If it gets to a jury trial, then I see where the sort of unclean hands is coming in.
Yeah, well, that's
I don't know that it'll actually get to that sufficient to meet the burden for the unclean hands defense, but it does sort of diminish the fact finder's ardor for the poor little plaintiff being taken advantage of.
Yeah, well, there is no manufacturing, as the court has already discussed, so there's nothing to protect except the intellectual property itself, and that's legitimate under the patent laws that exist today. There is some movement afoot to enact legislation to curtail what is sometimes referred to as troll patents. And this is what I consider this case to be. But they have a right to do that. The law permits them to bring a suit against anybody that they feel is an infringer, and being a manufacturer is not a prerequisite to doing that, so they're entitled to do that, and we'll fight the case with the law that we have.
Okay, so my question is, to you, is that what you're saying is because of the way you view the plaintiff and the plaintiff's motives, are you telling me that this case is going to be litigated to the nth degree, or if it's going to be litigated through to a trial, can we ensure that it does not become a war of attrition for your client as well?
Well, my client is, I don't know yet. Let me.
I mean, because I need for both, and I understand they do not. Their sole risk here is the patent in suit and any challenge to the validity of the reissuance and the costs of litigation. So they don't have as much on the line as your client may have in having to ultimately pay, if it chooses to settle, some type of licensing.
Well, they're not inclined to settle for the reason that I just expressed. They perceived that on their own before they hired me. However, the issue of whether or not we would settle this case is going to depend on the outcome of the research that I have in Indian, meaning subcontinent Asia, Indian law firm right now researching the prior art. This is what I refer to as a rector set patent, and by that I mean that it doesn't introduce any new technology. It's an aggregation of known parts and software, or very simple software. So there's no new technology disclosed in this patent, and that means that it's vulnerable to the location of more prior art beyond what they've already listed in it.
Okay.
And I will know a lot more in about a month about whether we will talk settlement or whether we will fight. But we're not going to fight just to fight. If we have a good basis to fight, we will. But if we don't, we'll settle.
Okay, then let me also ask, in the fight, can we make sure that we... Why don't you have a seat so I can also see Ms. Lipscomb at the same time?
I was watching you on the screen.
Okay. But I couldn't see you. Somehow or another, my video camera is not aimed on you, Ms. Lipscomb.
No, I see that.
There we go. Fantastic. Okay. There. Technology. When it works, it's great. So, how are we going to litigate this case? The first question that I have is, should this case be consolidated with the other lawsuits that I have involving this particular patent, at least for pretrial purposes, so that we don't plow this, so that I don't have to plow the same field with three different lawsuits. There's also Judge Moore has 2 pending cases. I have the lowest filed case, so I could consolidate all of them here for pretrial purposes. I don't know whether or not this is whether or not you have spoken to the plaintiff has spoken to defense counsel in the other cases, or whether or not Mr. Vandervoort has spoken to defense counsel in the other cases as to what is the most cost-efficient way to address. And I need for everyone to focus on, let's go for the juggler issues. And expend the resources in focusing on 3 juggler issues rather than every single thing that we can litigate. I understand the risks involved there. Nobody wants to have to face a client and saying, well, as a strategic decision, I gave that up, and that turns out to be a bad decision because I then am, quote, hit with the waiver issue. But on the other hand, I am very concerned about the cost and the time of litigation and the need to be as efficient as possible. And I see intelligent counsel that are very creative and should be able to help me. Okay, Ms. Lipscomb, since you were just speaking, you want to speak first, okay?
Well, I would like to respond to what the court just said if I have the opportunity. But I don't have to go now if she wants to go.
Okay. Again, if you want to speak standing up, I just asked you to come to the podium, and I can. Arun, do me a favor. Just move both the podium over so that when somebody is at the podium, it's not blocking Miss Lipscomb. Although I can look at her. This one. Move both of them over. Perfect. Brilliant. Okay.
Your Honor, as far as the other pending cases, I know that one of them is very close to settling, and with respect to the other defense counsel...
Which one is close to settling?
Well, I'm trying to remember which of the... I believe that it's currently in front of you. Is the...
Is the beach resort rental or the Burlington Coat Factory?
Burlington we are in discussions with, and I believe that that will be settling.
Okay.
And in fact, with the majority of the defense counsel, we've asked for, and usually when we contact them or they'll contact us, there's a few things that we're very willing to give them our claim chart up front. We actually sent our claim chart in this case already to Mr. Vanderwall. We sent it last night, so he should have it.
Do you have a copy so I can see it?
I don't have a copy with me, but I'm...
Okay.
We haven't been filing them. We've been serving them and not filing. Obviously, we weren't going to make it public record as of yet, and they're different, obviously, for each of the defendants, which is another issue. What I was trying to get to is that usually there's been some informal exchange of discovery, and that has been expediting these cases. We're very upfront with our position, and with respect to Mr. Vanderwall, he's informed me that his client is not interested in settling, and I had asked for some preliminary information, which we haven't received. I don't know. I suspect he's probably has asked his client for that. If we don't get it, my next step is obviously we'll just send out our first set of interrogatories. But I don't know that consolidating this case with the others will be more efficient for those other cases. I actually think it would...
Okay, so you have different claims as to each one of the defendants.
Correct, because not each one of the systems uses the same software. So if you consolidate the cases, the claim charts are going to be different, the claims will be different, there's going to be different evidence, and potentially we would need different experts and witnesses. So from our perspective, we do not want to consolidate. I don't know what Mr. Vanderwall's position is going to be, but obviously, I am very open to working with him. We'll give him whatever information informally that, we're happy to do that to try to expedite the case, and that is how we've been operating in the other cases. There's been,
Okay, so the only three claims that are at issue here are 1, 12, and 15?
15, correct.
And why have the parties not been able to determine where the...
One of the things that I have asked Mr. Vanderwall to ask his client is how many cameras that they're using on the property, so that we know what the extent of the defendant's use of the system is. I don't know what that is yet. He did tell me he would ask, so I don't want to misrepresent anything here. I'm assuming he has asked. We just don't know the answer yet.
So tell me, I skimmed over the patent. A little lightly reading always helps before going to bed. It helps.
This will put you to sleep. Sure.
So tell me the type of investigation that you have done before you filed the suit that helped you determine that you would only focus in on those three claims, because it helps me understand the patent and the nature of the alleged infringing products.
Well, the patent really covers, it's a surveillance type system, so, and there's different methods for triggering events and recording, and that is how this system
What do you mean
operates.
triggering events?
So, in other words, you can program the system so that if somebody, for instance, opens a door, okay. It sends a signal to the system, and it can then record, and the frame rate will then slow down so that it can be viewed. In other words, when it's recording, it'll go very quickly. And this has two methods of recording. So one, you can actually look at it, and then it can also be recorded. When you go to look back, say you program the system, so somebody opens the back door to your store, and it's after hours. So you can say if somebody opens the door after 7 p.m., I want the recording to slow down so that when somebody comes back later on to review the tape, they'll see it in more of a real-time manner as opposed to it being much quicker. Because if you actually look at a system that doesn't do that, the frame rate is much quicker, and so you can miss things. You'll miss details and perhaps even some time. So, and the different systems can be done. You can program them differently, and so not everybody has to have the same events. You can bypass certain things. So, not each defendant will use the invention in the same manner either. And so,
what would be the different ways that?
Well, because you can program your system differently than another. It has different capabilities, so you can, not everybody's going to program it so that it slows down for this triggering event as opposed to something else. Somebody might not even find that to be necessary. But
that doesn't sound like there's any uniqueness. That's sort of that's inherent in the invention. That's sort of the user manipulating the speed rate.
No, that's correct.
And
yeah.
So
no, but
that's external. I mean, the fact that it can be manipulated is inherent, but give me another example of how it would be different.
Oh, no, just the actual systems will be different. So not every system, not every defendant will use the same software manufacturer. So it might be.
And who are the software manufacturers providing the component of the software, and what does the software do?
There's multiple different companies, more than 100 companies that can do this, that sell this software.
So
and it is present in the claim chart. So when you look at it, they'll know who which software will apply to that particular defendant's usage.
Okay, but your patent does not encompass the software.
I'm not sure how you mean encompass. It covers it, yes.
How does your patent cover
you
somebody
need the software.
else's software?
Well, you have to have the software for the whole system. I mean, the system is, when you look at the system, and it has parts, it has cameras, it has recording devices, and then it also has the software that makes it operate.
But if different people design different softwares that are able to be used.
Maybe I may have misspoke. The software will operate. Each one of the different companies, their software will be infringing. Will allow the end user to infringe. It doesn't mean that the software is not unique in the respect that. That it makes the systems operate differently. It's just that the defendants themselves can manipulate the software so that not every defendant's usage is the same.
Okay, but let me make sure I understand. Are you saying that all of those software manufacturers are infringing your patent?
No. Well, that gets into a whole other area, because they're not. The software itself isn't. We have taken, that's actually part of, if you look at the one of the case, that's why I don't want to really go into this right now. One of the manufacturers has actually sued us which is one of the case that you mentioned where we were the defendant in the action.
The Genentech case?
The Genentech case.
Genentech.
They are claiming that, I believe it's their position that we are, they're actually seeking an injunction, a declaratory judgment saying that they are not infringing. And we came back and said, well, your system can infringe, but there's positions where they can say. I guess the problem is, and I'm trying not. I don't want to speak in this case about that because we haven't really developed our entire defense to that case yet. So if you will excuse me from delving into that, but there are issues of contributory infringement and inducement, and those are issues that are going to be in that case. So. I don't know that we have not sued any of the software companies ourselves, and have done that on purpose because there are different issues and there would be different claims in those cases, different theories of liability as opposed to direct infringement against the end users such as defendant.
Okay, but help me understand what is the innovation that is inherent at the heart of this patent?
It is a very it's a very complex system for it's a very complex surveillance system. You have to, and it's an expensive system to put together and to operate. You have to, at some level, have actual people operating it. So there's several.
But human beings are not covered by a patent. So
no. But we do have a method claim as well. I mean, we have two systems and a method claim. But the heart of the patent is the way that it is recording and the way it's recording and allowing the end user to view it at the same time. So it's a really, I don't know how better to explain it. It's a very complex surveillance system that's in very broad use. You're not looking like I'm explaining this well. I'm trying to give you. I don't know, without getting incredibly technical. I don't know how else to describe it.
Well, part of the job of the lawyers is to be able to teach it to the jury.
Correct.
And so
I will get there.
I am giving you all an opportunity at no extra charge to start the teaching process, because if I can understand it, then any jury can understand it, is the rule of thumb that I always use. So if I don't understand it, then you've got some work to do.
I know, Your Honor. Yes, I apologize. I was not prepared to describe it today, but obviously, of course, when we are in front of a jury, there will be demonstrative.
I'm intrigued by Mr. Vanderval's statement that this is simply an erector set. I'm always chuckle at descriptive words, and I should tell both sides, whereas that makes fine reading the first sentence to use the attention-grabbing words sometimes can get overused, and to me, now as I'm going on 16 years on the bench, my experience tells me it's a lawyer that starts to do that usually doesn't have the facts, and so they're dazzling me with their wordsmithing. And I'm ultimately interested in what are the facts. So let's use his words, erector set. And so what I perceive as an erector set is that you buy component parts and you simply put them together, and that there's really no invention involved here except somebody decided to take the component parts and put them together. So then that's maybe more of a method that is covered by the patent than is something as to the...
Well, there are two system claims as well, but, and I apologize, Your Honor, I am not the technical expert on this, and had I known that I would be describing, or that we would be describing the patent today, one of my partners would be here to better describe it for you. But, you know, I unfortunately, I don't know how to respond to the Erector said. Obviously, I would never adopt that kind of terminology for this patent. I don't agree with his, with a lot of with what Mr. Vanderwall said.
Okay. I'm throwing that out,
yeah.
and I'm tossing it. I'm now asking you to just sort of begin the education process so that I understand what is the patent and how do you say that they are infringing it, saying it is in as simple to understand layman's terms. And I would think then that you would be in a better position than somebody who gets lost in the technology and speak in acronyms and other jargon, and everybody's going, yeah, thanks. And their eyes glaze over.
Maybe the best thing to do would be, I can have a claim chart provided to you today. I'm really, I don't know how better to, and I am not prepared to today to better describe it for you in more technical terms. And if I do, I'm concerned that if I do, I will misstate something that will prejudice my client going forward.
Okay. And I appreciate that, and I don't want to put you into a situation where you end up with a gotcha situation.
Correct. I don't want to have to file something later on telling you that I misspoke. I am trying to avoid that situation.
Okay. Then let us look at, since we've disposed of any efficiencies that are achieved by consolidation, let us focus on the how are we going to come up with a case management plan here that will work? And I am open, since I have people that are not newbies in the area, to use this as an opportunity. If you've got any suggestions for how we do this more cost efficiently, I'm all ears. I looked at Judge Moore's recent order, or his standard order that he uses in a patent pretrial order, in which he sets out a number of patent disclosure requirements, followed by which has the first, try and keep my orders short because have found that lawyers don't read anything more than 3 pages long unless it's in text. But I also respect and admire Judge Moore very much because he's a very efficient kind of guy. But he has the patent disclosure section and a claims construction proceedings. And under the patent disclosures, he has a disclosure of the asserted claims and infringement contentions with various subparts. Then he has the invalidity contentions. And then he has a disclosure requirement in patent cases for declaratory judgment of invalidity. Is the defendant really seeking an invalidity based on prior art? Is that where you see yourself going?
That's what we're looking into, Your Honor. Okay. We don't have the benefit of the research yet, so
Okay.
That's a possible defense, but we haven't established what the prior art is at this point. So that's why I can't really address in any meaningful way today what the prospects of settlement are, because the prospects for settlement depend on the research that is ongoing at this point.
Okay, and you think that that will be completed within a month?
Yeah, it might be a little bit more than that. We have it. We're taking it in 2 stages. We're doing a certain number of hours that we've agreed to. I have the good fortune of having a fellow practitioner who is an expert on the patent classification system, and that is how searching is done. The patent classification system in the United States, he's an expert in it because he became an expert when he was employed by the Patent Office. He was at one time a patent examiner. He's also a registered patent attorney.
How is the patent classification an issue in this case?
It's not an issue in this case, but it is the key to finding prior art.
Oh, okay.
So the Indian firm that is doing the research is operating pursuant to instructions from him as to where the ideal areas to search are.
Gotcha.
And that's because of his knowledge of how the classification system works. So, for example, you have an examiner in a given patent application who searches based on his or her prior knowledge of this field, because each examiner is in a very particular area. Mm-hmm. And they already know a lot of prior art when they start to search for a particular patent application. But these examiners are not all experts in the classification system. So you take an expert like my friend is a lawyer by the name of Jay Spiegel. Spiegel sees the invention in the issued patent, and he sees what art, not what art units, but what classes and subclasses were searched because they appear on the face of the patent, and then he comes up with other classes and subclasses that the examiner did not use to find prior art that the examiner did not find. And the probability is, and I haven't checked this, but all of these cited prior art references on the face of the patent, which is an obvious attempt to try to bulletproof it against an invalidity claim, they probably are all in those classes that were disclosed by the examiner where he searched. And we have he composed a chart of the examiner's search areas, and he's made recommendations to the Indian firm as to where else to look. So I won't know the outcome of this until I find out the first level results, and then a decision has to be made as to whether to go further or not.
So what you're basically saying is, Judge, everyone else needs to cool their jets for 6 weeks until I get my research done?
Well, I wouldn't put it that way, but yeah, you're right.
Okay. That's the bottom line, isn't it?
It could be. It could be that we take a look at the results of the search, and that we'll decide this looks like a wild goose chase, and maybe we ought to talk about settlement. I'm not at all, my client is not at all of a mind to settle, I'll tell you that. But if I come back to them and I say, our search does not look like it's going to go anywhere, and I'm not inclined to waste your money to do more of it, maybe we should talk about settlement, because it doesn't look like we're going to have a very good shot at invalidity.
Okay. And then, Ms. Lipscomb, let's say that they come back to what inducements do you have them from the settlement perspective?
You were asking me that, or?
No, I'm asking Miss Lipscomb. She's the one that, she also wants to look good with her client. And so the question is, if you can save your client the money of litigation and get them to settle earlier rather than later, you need to...
My client's incredibly reasonable, and I would, of course, explain to them what the cost-benefit analysis would be going forward. And absolutely, if he comes back with something, I have the benefit, obviously, of being able to speak directly to the inventor.
But I'm pushing you. I want to push you to make it so attractive for them now that having Mr. Vanderwall, they've gone to a very respected somebody who is going to tell them straight.
I will absolutely
give them a cost-benefit analysis, and he's not going to waste their time. And so what I need to, I don't want you sitting there twiddling your thumbs, doing nothing for 6 weeks. I want you to be out there saying, my client is making such a deal, is going to offer you something that he goes back to his client and say, we're spending X amount of money to do this research,
Your Honor, this actually goes back to what I said earlier. Mr. Vanderwall and I have spoken on several occasions, and I am aware that he is undergoing this research, and as is my client. And I asked him if his client would entertain a settlement demand at this point. He did not seem receptive to it, but did say that he would find out from his client how many cameras they were using, which is how one of the things that my client has asked me to determine in order to come up with any kind of initial settlement offer or demand. I haven't received that information from Mr. Vanderwall. As soon as I do, I will be sitting down with my client, and we will have a heart-to-heart about where this is going, and we'll come up with...
Okay, so the ultimate settlement demand is contingent, a factor in the settlement demand is the number of cameras?
My client would like to know what the extent of the defendant's use is. I don't know that is absolutely outcome determinative, but it's a very simple question. Whenever I've asked any other party for this, I've received the information incredibly quickly. They're happy to supply that. As soon as I get that, that is the one thing my client has asked me for.
Mr. Vanderwall, why can't you give her the number of cameras your client is using by Friday?
I can, and I will. I'm not allowed to speak to her, but I'll tell the court that the number is 117 to 119 cameras.
Okay. Why aren't you allowed to speak to her?
Well, because in my experience, judges don't like the lawyers talking among themselves.
Okay.
I didn't understand that.
Okay. Okay. No, you're right. You need to be conversing with me. You're very, very perceptive on that. But so you now have your number.
I can represent to you that we will be in contact with Mr. Vanderwall very quickly.
By Friday?
By Friday, absolutely.
Wonderful. Let us look at, just needless to say, if this case settles, I have another closeout. And before the end of the month, keep in mind that truth and justice are very important. Statistics reign supreme.
We'd love to make you look good, Your Honor.
Well, being a senior judge, it's much easier than being an active judge where, and just keep this in mind, it's always important for lawyers to understand the mindset of the judge. Each month we get a colored chart that shows us in comparison to everyone else how many cases came in, how many cases went out. And so, as you can perceive, most judges are type A, anal compulsive, and there's that little bit of, I don't want to look to be that I'm not doing my job. Everybody else is moving their cases. I'm concerned that the parties have an opportunity to have their day in court, but on the other hand, whatever I can do to help the parties resolve and make the lawyers look good in the eyes of their clients, I like that too. Again, this goes back to our tripartite partnership, that I hope at the end of this, that especially Mr. Vanderholt, since you've been doing this long enough, and it sounds to me like Ms. Lipscomb is a very savvy practitioner. Some of my best cases came from former opposing counsels because of the relationship that we developed as professionals, because clients come and go. We're still a member of the bar. So, is everyone happy with this joint proposed schedule that you all came up with?
Yeah, Your Honor, if there's just one thing I want to bring up today, there's one thing that I believe in your order that hasn't been done, but we've been in contact with Mr. Vanderwell's office about it, and that is the election to the magistrate. Mm-hmm. We told him we were fine with, okay, all right.
I have it, but my problem is technology right now. I have no internet access.
What happened?
Since, it's been up and down the last week. And yesterday afternoon, around 3:30 in the afternoon, I lost it again. So I did the election regarding the magistrate,
okay.
and I brought it here, but of course we can't file it that way. So when I get my internet back, maybe later today, or maybe it's done already, I don't know, I haven't been to the office yet, then we'll file these things that I have backed up.
Okay, I haven't sat down with Judge Turnoff yet, because I have found that the different magistrate judges have slightly different procedures on discovery disputes. But my goal is to make sure that the lawyers have had a chance to really work it out, and they have to use the procedure. Don't come back to me 3 months later and say, nah, 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 he didn't give it to me. I said, well, why didn't you come to me so that I could do something about it? And I want to make sure that there's not a lot of time spent on filing motions, albeit that I do find that sometimes writing things out helps people clarify their thought process. But I presume that I've got counsel that can clarify their thought process, and then without the need of putting it in paper, and then articulate why they believe their position and their solution to the problem is the most reasonable one. Okay? So there's going to be the switchover in April. I'm going to try and make it as smooth as possible, and we may not even get to any discovery disputes before the shift, but I just want to give you that heads up.
Do I understand that the magistrate judge is going to change from Simonton to Turnoff?
Correct.
I see. Well, we haven't had any discovery disputes yet, and we may not have any, so we'll try.
Okay.
I would like to address one or two things that happened in your dialogue with plaintiff's counsel that I didn't want to interrupt. But,
okay.
First of all, the court was talking about consolidation of the cases, and I have an opinion about that. My opinion is that it's premature to really talk about it because there's a considerable I have been talking to other counsel who are representing clients that have been also sued by Hawk. And it makes good sense from my standpoint to find out what other defendants' lawyers are thinking in regard to this particular patent and the litigation. And what I'm perceiving is that a lot of these other defendants are much more inclined to settle than we are at this point in time.
So you agree with me that consolidation is not appropriate.
That's right.
Okay.
For now. If it turns out that I feel otherwise later, I will tell the court that.
Well, before I move to consolidate, before I consider any motion to consolidate, there really needs to be a clear joint agreement that that is in the best interests of everybody, and I need to be shown why it will make it more efficient.
Okay.
Because if different claims are involved, I don't know whether or not the terms in the claims that are in dispute, because that's ultimately where the heavy lifting for the court is making sure that I understand the technology sufficient so that I can come up with a definition for the disputed terms that a jury can understand.
Yeah, I don't think that we're anywhere near the point that we can have a Markman hearing, for example, because we haven't determined whether there are disputed interpretations of the claims.
And that's part of my problem, which is the reason why I looked at this notice of terms genuinely in dispute, and this, which is docket entry 18, this is not responsive.
Yes, I thought when I saw that you might be talking about terms, meaning terms in the patent claims, and that what you wanted to hear is what you might have to resolve with a Markman hearing. But we were way before that point. We couldn't possibly address that question at this point in time.
And that's why I'm asking you, I'm holding you to the 6 weeks. You tell your client that I need to know within 6 weeks what your defense is going to be.
That's fair.
And then I need for you to, I see that you have a deadline to join the parties of March the 12th. I didn't see a deadline for amendment of the pleadings.
I believe it's
it's July, okay. So by that July 14th date, deadline to amend the pleadings, then Mr. Vanderval, I need to have an answer, an amended answer filed that really gives me the statement, and I'd really like to have it before July, because until I have the pleading set, I don't have, and the magistrate judge doesn't have, the framework for what is the scope of discovery. Because your client does not want a fishing expedition, neither does the plaintiff want a fishing expedition, but you're the one that be more subject to the fishing expedition calamity. I want to make sure that the discovery is very focused. I would hope that the disclosure, the voluntary disclosure, minimizes the need for discovery. But I am just concerned that the deadline for amending the pleadings, and I understand what Ms. Lipscomb says in challenging your answer. Just the idiosyncrasy of this judge is that I hold the defendant to the same standard under Iqbal and Twombly that I hold the plaintiff to, because the whole purpose of the pleading is to put the other side on notice as to each side's respective position, and you need to allege the facts that support it. And I think that you yourself will concede that right now you don't have enough information, so you are reserving because you didn't want to waive certain defenses.
That's right.
But I can't wait, nor can the plaintiff wait, until July for you to decide what your defenses are going to be.
I don't need to July.
Okay, tell me, when can you file an amended answer that that satisfies the Iqbal and Twombly?
Well,
I want your clients to be able to be satisfied that you have done your investigation and can advise them.
I would think we could do that by the end of May and maybe before.
How soon, maybe before?
Well, Judge, I have two phases with this search that I was talking about that the Indians law firm is doing. They're going to give me a preliminary report in several weeks, maybe 3 weeks, and then I have to make a decision about whether we're going to go back to the well or not. And I won't know what that decision is till I see what they come up with.
And when you go back to the well, what will that entail?
That will
How much time?
It will entail more searching.
How much time?
Another 3 weeks or so, maybe.
So we're back to the 6 weeks. May is more than 6 weeks.
Right. Well, you have to have time to review it too, so it's not just their time. What we're going to get is a bunch of patents, and they have to be read and understood in comparison to the art taught by the patent in suit.
Okay, but based
time.
on, excuse me, but based on the times table that you've given me, this is mid-February.
Yes.
By at the end of the first week in March, at the very latest, because whenever they started their research, I'm sure it wasn't today, you're going to have the results of phase 1, correct?
Correct.
Let's say you have 2 weeks to review it. Is that enough time?
Yes.
Okay. Then you can make a decision. Do I need to go forward? So what we're really saying is you need 8 weeks, correct? So at the end of April, you should have, at the very latest, you should be able to file an amended answer, correct?
Yes, I guess so.
Okay. I appreciate that very much. Then you don't need to brief the motion that the plaintiff has filed. Save your client that money.
I did already. I've turned.
You did?
I briefed it. Yes.
I didn't see that. Hold on.
It was filed several days ago. Friday. It was due on Valentine's Day. And I filed it.
No, you're right. You did. You did. I'm
shortly
sorry.
after 6 o'clock on the 14th.
Okay.
That's unfortunately not an easy memorandum of law for your clerks to research because it involves a lot of law reviews that you probably don't have access to. But that's what I had to work with, so that's why it's there. One more thing before I sit down, if I may. The court asked plaintiff's counsel some questions about the patent, and I would like to address a couple of those things.
Okay.
Since I have a little bit more, maybe a bit more experience than she does. These claims in this reissue
This way,
patent.
Miss Lipscomb is going to improve her game because it's like tennis. You always want to play against somebody who's more experienced than you.
The patent has a number of claims. The ones that you always look at first from an infringement standpoint are the independent claims, which are the claims that the first several of the independent claims are the ones that I now understand are being asserted.
It's 1, 12, and 15.
Right. They're all independent claims.
Correct.
They are they are always the broadest claims. So it's easier to find an infringer with an independent claim than it is with a dependent claim. The patent claims of this patent are two kinds. There's apparatus claims and there are method claims. The method claims don't teach how to build this thing. The method claims teach how to use it.
Right.
And there was some talk between you and opposing counsel before about making something. It was not making it, it's using it. And the apparatus claims, of course, describe an aggregation of parts. The patent does not protect against infringement with software because it's an aggregation of parts and software. And so you have to have all of the elements of a claim found in the accused device or method or process. They all have to be there in order for there to be literal infringement. And for doctrine of equivalence infringement, they all have to either be there literally or with an equivalency. So in looking at this patent to understand what it covers an aggregation of parts and software together. Mm-hmm. So there would never be an issue as to whether or not some software manufacturer or infringing the patent. The most that it could ever be is they might be a contributory infringer. And you have to sue them for that if you're going to do that. That's very unlikely. I think it's very unlikely that we'll need to amend the answer, because the answer, except for the standpoint of adding detail, plausibility to the affirmative defenses, that we certainly can do that.
That's what I want.
Okay, yes, of course. Well,
right, that's my problem with this answer.
Yes, I understand what your problem is.
Okay.
And I didn't have a choice because I didn't know anything about the prior art at the time that we filed the answer in affirmative defenses. But we can fix that.
Okay.
And we can also drop affirmative defenses that aren't found to be warranted by the discovery.
That's what I expect you to do.
I will do that.
Okay. I expect that by the time we come to the end of May, that I will have an amended affirmative defenses that set out the juggler affirmative defenses that you are going to go on with the factual basis to support why those are viable defenses. Because ultimately, let's keep in mind, if this case goes to the jury, do you want to be in a position of saying, well, here's my defense. If you don't like that one, let me try this one. You don't like that one? Let me try this one. You know as well as I do, that's not a really effective way. You maybe can get away with a max of 3 affirmative defenses, but it's always better to go with one. On the power of persuasion, on the burden of persuasion.
Yeah,
the same thing with the plaintiff. The plaintiff needs to make it so crystal clear that there is in as simple way as possible, that there's the juggler, there's the infringement. Thank you very much. I sit down. I've made it very simple. Why are we debating it? I mean, that's the way you try a case to a jury.
That's exactly what I've been doing for a long time.
Okay. And so I'm relying on you to help me as part of our partnership to make sure that you're not having to brief, you're not having to respond, and I'm not having to decide things that are collateral issues. Let's stick with the real, the juggler on both sides. And if your research shows that there's been a prior art problem, I predict this will be a very nice and quick settlement. They will want you to go away.
Well, if I find the prior art, there's not likely to be a settlement. If I don't find the prior art, there's likely to be a settlement.
But who knows? Even, there will probably be a confidentiality agreement that you can't tell anybody else.
Judge, we can have a confidentiality agreement if it's a settlement, but since there's no competition between the parties, there's no need for like a protective order that we get in a lot of cases
Right.
where the parties are competitors. That's not the case here at all, so there's no need for that here.
No, but I'm looking at if this is their business model, which is basically what you're saying. This is their business model. They were unsuccessful in manufacturing themselves, and they have found through the litigation process as a way to make money without having to incur the risk of manufacturing themselves. They don't want to have somebody kill the goose who lays the golden eggs, right?
I assume so.
Okay, I'm going to adopt the party's proposal, except I'm going to move up the amendment of the pleading dates to earlier in May. Is there a particular desire as to a date in May? Shall we make it the
May 15th?
May 15th? Okay. Do you want to have the joinder of the parties at the same time?
Yeah, I doubt there's going to be any parties added.
We're fine with that. I don't believe there will be.
Okay, I just like to make sure that we've got, okay. Okay, one other thing, if there is a Markman hearing that is necessary, I'd like to have the tutorial before the Markman hearing. Let me share with you how I prepare for a Markman hearing. I read the briefs. It's more helpful to me if I have read the briefs once, then have the tutorial, then can reread the briefs again so that I can itemize the particular issues that I need for the parties to focus on. I also want to have a joint statement of terms that are genuinely in dispute, and I'd like the parties to ultimately narrow it down so that it's under 10, so that we're not trying to write a dictionary here. We're dealing with the terms that really are the juggler issues. I'm beginning to sound like a broken record with the word juggler. But I do believe that if you know my mantra, then we're all on the same wavelength. So when would you all like to file a joint statement of the terms that are in dispute and the statement of terms, the definitions of statements that are not in dispute?
Your Honor, has this been assigned to a track yet? Is it standard track?
It'll probably be a standard track based upon the 18 months. I don't see anything complicated that would make this a complex case.
No, I'm not suggesting that. I don't think it should be a complex. It's a complex case compared to a wrongful termination case. But it's not. It doesn't rise to the level of the definition of a complex case according to the rules.
If you file the joint claims construction and on July the 17th.
I don't. Excuse me, Your Honor. I don't think there's such a thing as a joint claims construction. A claims construction is a claims chart asserted by the plaintiff. And you're never going to get a defense lawyer in a patent case to agree, in all likelihood, to agree with what the plaintiff's position is on a claims chart.
Well, you'll be surprised in the last couple of cases that I've had. That's the reason why I've put that in there. And maybe it means that out-of-state lawyers are more cooperative than my Florida bar members. I don't like to think of that as even a possibility.
Well, let's see what happens.
Okay. I mean, let's find out. Because ultimately, the plaintiff, I understand what the parties' respective positions are. The plaintiff wants to make it as broad as possible. The defendant wants to make it as narrow as possible. That is zealous advocacy that is out of balance with one's responsibility as an officer of the court. Can I emphasize that again?
I don't think you need to.
Okay. And that, in litigation, each side is going to take hits. And let's figure out where is the one that you cannot, that is the killer. And if the plaintiff has to recognize that they can't have it, ultimately we will all come to Jesus. And salvation will walk in the door. Okay? I will be happy to show you what lawyers in other cases, and that's why I have been pushing for, if you sit down and you start working out, each side comes in with their statement of the claims in dispute, and I say, great, that's wonderful. Now which ones are really important? And let's keep them under 10. I have good lawyers who are great problem solvers. I want to see your creative juices so that I can show them off to the jury. Okay?
Yes.
Anything else for the good of the order?
No, Your Honor, not from the defendant.
Okay. And good luck with your research. Sounds to me like you're going to help everybody grow in wisdom. And it sounds to me that Ms. Lipscomb and her client is always amenable to being educated. And she and her client are going to be giving your client a settlement demand by Friday.
That is correct. Yes.
Okay?
From a timing standpoint, I've already committed a certain amount of money to this Indian law firm to do the searching. Until I get the results of the search, 3 weeks or whatever it is, hence, I'm not going to know.
And I think she understands that now. We have set our timetable, so she's going to make the demand.
That's fine.
Your client is not going to jump at it, but your client will have the chance to think about it and not just simply react viscerally.
Yes, okay, that's fine.
And you, in the meantime, will be able to pull together that information, and so that they can then look at the demand from a business perspective.
That makes perfect sense.
Okay. Thank you, sir.
Thank you.
Thank you.
See you all.